I call the Honourable Member Holly Walker.
Thank you very much, Mr Chair. I'm pleased to take a call on part 3, and in my contribution earlier I mentioned that there were some assurances that the Green Party had sought since my contribution in the second reading last night. And in this part I want to focus on those and talk about those because in my contribution to the second reading last night I outlined a number of concerns that the Green Party held with clauses in this part of the bill, namely clauses 21 and 23 about the powers to obtain information for inquiries under the new legislation and about the disclosure of evidence. And just to remind the House, those powers are quite extensive. Under Clause 21, an inquiry may, as it thinks appropriate for the purposes of the inquiry, require any person to produce any documents or things in that person's possession or control or copies of those documents. And under Clause 23, an inquiry may, on its own initiative or on the application of another person, order any person to disclose to any person participating in the inquiry any specified document, information or thing that the person has produced for the inquiry. So quite extensive compulsion powers, and new because they will now apply to government inquiries as well as commissions of inquiry. So last night we abstained at the second reading because we had a number of concerns about this. We were concerned that on a face value reading at least, the powers in those clauses could have required, for example, journalists to disclose their sources or MPs to disclose their private communications with their constituents. And I outlined these concerns to the House last night. And I think we had in the House quite a helpful response from the Honourable David Parker, who made the link between this legislation and the Evidence Act via Clause 28, which gives witnesses and other participants in inquiries the same protections as would apply to civil proceedings under the Evidence Act, and that was a helpful contribution from the Honourable David Parker. But the privileges that he listed in his contribution last night alone weren't enough to allay the concerns that we had. So I took a closer look at the Evidence Act myself this morning, and I did find it reassuring regarding the two specific concerns about the protection of journalists' sources and the protection of MPs' communications with their constituents. Because the part of the Evidence Act that applies in this situation to this bill includes Section 68 of the Evidence Act. And Section 68 of the Evidence Act actually explicitly makes clear that a journalist cannot be compelled to disclose the identity of their sources in any civil proceeding. And because this bill treats an inquiry in the same way as a civil proceeding would be treated, that clearly gives a clear indication that journalists' sources would be protected and would not be able to be compelled to be disclosed by an inquiry under this legislation. So that was the first assurance that we sought, and we are reassured by that. Similarly, Section 69 of the Evidence Act, which also applies via Clause 28 of this bill, provides protections for confidential communications not to be disclosed, including the protection of particular relationships and including protection for the free flow of information. And our reading of Clause 69 of the Evidence Act is that this would also therefore cover MPs' communications with their constituents. And that's very important because while in the Green Party we absolutely support greater transparency, both in the conduct of inquiries like public and government inquiries, but also more generally in terms of the coverage of the Official Information Act, which we believe should apply to parliamentary services, it's very important that confidential communications with constituents are protected in both scenarios so that people can contact MPs with the confidence that the information they share with us will not be disclosed publicly. So we are again reassured by the application of Section 69 of the Evidence Act that these concerns are adequately dealt with under this legislation as well. Now, the other area of concern which I canvassed last night in the second reading relates to parliamentary privilege. And we had a question in the Green Party about what would happen if the Henry inquiry into the leak of the Kitteridge report into the GCSB was held under the new legislation, what would have happened in that situation? Because under the current law, ministerial inquiries have no power to compel witnesses to appear before them or to disclose evidence. But under the new law, the equivalent new government inquiries will have those quite extensive powers to compel evidence. Mr. Chair.
Holly Walker.
Thank you, Mr. Chair. The new equivalent government inquiries will have those extensive powers outlined in clauses 21 and 23. And so we have to be quite careful in teasing out what this means in practice to make sure that we're not inadvertently, inappropriately extending powers that could impinge on parliamentary privilege. And we were concerned about the potential misuse of that power in ministerial-driven inquiries to compel the disclosure of information like email records, like phone and swipe card records. Because after all, clearly in the case of the Henry inquiry, some compulsion was felt by parliamentary services to disclose that information, even though there was no power of that inquiry to compel the disclosure of that information. And so our concern was, if that's what happened in a situation when the inquiry had no power to compel that disclosure, what would happen in an equivalent inquiry if that power did exist? And we were quite concerned that that could involve the compulsion of the disclosure of information that is subject to parliamentary privilege. Now, Mr. Chair, this does come down indeed to a question of whether such communications are protected by parliamentary privilege. Because if they were, they would be protected under this bill, because along with all the other kinds of privilege that are protected under Clause 28, parliamentary privilege is protected. So the nub of this question really is whether those communications that we saw in the Henry inquiry are protected by parliamentary privilege. And it's our view in the Green Party that they are, and that's why my co-leader, Dr Russell Norman, indeed wrote to the Speaker inviting him to consider that matter, and that's what resulted in these matters being referred to the Privileges Committee. Clearly they're now the subject of a live inquiry by that committee, which took place, the hearings for which took place today. And ultimately the Privileges Committee will rule on whether privilege applies in these particular types of situations. It's our view that it does, but that's a matter for the Privileges Committee to decide. And indeed, we may eventually see parliamentary privilege legislation come before the House to clarify these matters. In our view, it's very important that these matters of privilege are clarified, and we do still have a concern that the powers of compulsion granted under this legislation, if those matters of privilege aren't clarified, could be applied inappropriately by ministerial-led inquiries and see encroachment from the executive into the territory of the legislature in terms of breaching parliamentary privilege. But we are satisfied that according to the letter of this law, parliamentary privilege is protected under this legislation, and what we have to ensure is that it's adequately understood and respected by ministerial and government inquiries in future and not encroached into in the way it was in the Henry inquiry. So because of this, these assurances that we've sought, and I want to also acknowledge and thank the Minister's office, Minister Tremaine's office, who turns out is in charge of the bill, for the response he gave us indeed today on these matters, which confirmed this interpretation of the sections of the Evidence Act in the matters of parliamentary privilege. I'm pleased that to be able to tell the House the Green Party can support the legislation. We will no longer abstain. But it's good that we have had the opportunity to put these concerns on record and have them considered by the Committee of the Whole House, because they are very important. They do go to the heart of principles about democracy, and we are concerned that this legislation, although it's needed and needs to be modernised and has been on the order paper for a long time, is in the space of this week being rushed through quite quickly. And so it's important that the House takes the time to consider these matters seriously, and I thank those members who have taken our contribution seriously and responded to it both in the second reading and the committee stages. I think it makes for better lawmaking, Mr Chair, and hopefully in the end a better understanding of how these important matters of privilege and confidentiality will apply under the new Inquiries Act.
Mr Chairman.
I call the honourable member Andrew Little.
Thank you, Mr Chairman. Pleasure again to just to make some comments on part 3 of the inquiries.